The attorney-client privilege protects confidential communications between a lawyer and a client. The purpose of the privilege is to encourage full and frank communications between attorneys and their clients so that the attorneys can give candid, appropriate advice. But what if a client communicates to a non-attorney who works for a law firm about a legal matter? Can the attorney-client privilege protect such communications? The Second Circuit Court of Appeals considered this question in United States v. Kovel. Louis Kovel, a former Internal Revenue Service or IRS agent, worked for Kamerman and Kamerman, a New York City law firm specializing in tax law. Around 1961, one of the firm's clients, Stewart Hopps, was being investigated for federal income tax fraud. During the investigation, Kovel was subpoenaed to appear in front of a grand jury in the Southern District of New York. In particular, the government sought to question Kovel about communications he had with Hopps. In response, the law firm advised the government that because Kovel was under the direct supervision of the firm's partners, he couldn't disclose any communications he had with Hopps unless Hopps consented. In response, the government responded that Kovel wasn't an attorney and therefore the privilege didn't apply. During the grand jury proceedings, Kovel refused to answer some of the government's questions and asserted the attorney-client privilege. The judge then directed Kovel to answer, stating that he had no privilege. After Kovel refused, the court held him in contempt, sentenced him to a year's imprisonment, ordered immediate commitment, and denied bail. The grand jury then indicted Hopps. Kovel appealed to the United States Court of Appeals for the Second Circuit.